Ladies and gentlemen, a very common problem which is faced by our international clients is that they have an Israeli partner or had one, and it stopped paying them. This is quite well known. Some Israeli enterprises tend to know that the foreign partner will abhor from judicial proceedings and also take substantial risks by non-paying. Now, usually US and European companies, they tend to ensure in their general terms of contract and in their specific agreements to have an exclusive jurisdiction at their home jurisdiction and to have their home law to be applicable on the case. This precaution might be reasonable in many cases, but has a whole bunch of problems when having an Israeli partner, and I guess that's not only Israel, it's in other countries the same. The first is that you waive the possibility to get to the debtor, to the Israeli debtor quickly in its home, and to, in particular, to get to its assets quickly. The Israeli debtor will know that as soon as you have such a jurisdiction, and will use this jurisdiction clause in your own contract against you and will throw you out of Israeli courts. The main problem is that you waive with that the possibility to place a freezing order against the Israeli debtor. Under Israeli law, freezing orders are possible even before filing the claim, and the first decision is taken ex parte. For non-lawyers, it's taken without hearing the other party, and it will be upheld for the whole time of the proceedings. Again, for non-lawyers, the freezing order is that the court will freeze certain assets of the Israeli debtor, and therewith ensuring that your debt will be covered at the end of the proceedings if you win the judicial proceedings. And that's a very potent and important instrument, especially under Israeli law, which is quite liberal with this instrument. I do not know any foreign judge, such as German, European, or US, who will provide in your home jurisdiction a freezing order for assets situated in Israel or any other country. That means that with your judicial clause in your contracts, you waive all these possibilities. And what you should do is stipulating in your contracts and in your general terms, not an exclusive jurisdiction and an exclusive applicable law, but your possibility, and only yours, being a claimant, to choose between the home jurisdiction of the debtor or your own jurisdiction, as well as the applicable law of the debtor or your home law. This enables you to take the relatively difficult decisions where to sue in real time, and not 3, 4, 5, 10 years before there is a case of suing someone. And it will enable you to take into account all the practical consequences, for example, how high the claim is, the judicial costs at home and here in Israel, and so on. So this is one advice how to avoid very long proceedings, which might be very costly and maybe not even cost effective. Have a nice day.